This is let's see. I'm not sure who filed this motion. This was you, Marvin? Yeah.
Yes, I did.
All right, what do you have to add to it?
I wanted more. I don't really have nothing to add to it because everything I said
Okay.
was
All right.
already in the statement that you got.
All righty.
I just wanted more parenting time with my child.
Okay. Um, Miss Watson, what's going on? I didn't get a response from you, so
Yes. Can you hear me?
yeah.
Oh, well, just like what Marvin was saying, I guess he just wanted more time with his daughter. Like I said, I never had a issue or problem with that. I
Right.
guess we just couldn't come up to an agreement, and
Agreement. Okay.
things was going back and forth, and yeah,
Right.
it was just a lot of disagreements.
No problem. That's well, there's nothing in writing in the court file on specific parenting time. So either party can ask for specific time at any time. Okay. That way it is written out. That way everybody knows when the parenting time is going to occur and what's going to occur during that time. Or not during that time because that's not something the court controls, but I meant everybody knows when it's going to occur, when the pickup and drop offs are, how
Mhm.
often, vacations, holidays, those kind of things. So since there is no written specific parenting time, the court by law sends this to the front of the court. You've had your fees waived by statute. So I will send it to the front of the court for custody and child support because it's been a while since either one has been reviewed. And they will help you get through this and what they'll try and do is see if there's any agreements the two of you can have. And if you can't agree, they will make a recommendation. All right. Any questions?
Okay. Yeah, and I also wanted to take her to get a rape kit too. Also.
You have no illegal authority to do that.
Okay. The CPS worker recommended it.
I was going to say if CPS is involved, CPS can do it.
They did, but apparently the mother now from the CPS worker said that they denied it. So I was trying to do it myself because I want to
Well,
know.
if somebody denies something like that and CPS thinks that it's relevant, they'll bring it to court.
Yeah, I never denied anything like that.
Yeah, they have to have some very specific reasons for doing a raid on a child. And if they have those reasons, generally the prosecutor's involved and so is a bunch of other people. So is CPS still involved, Ms. Watson?
As of now, yes, to my knowledge.
Okay, but they have not removed the child from you.
No,
From your care. Okay.
no.
And they have no problems with Mr. Lofton having any contact with the child, correct?
No.
Yes, correct.
Okay, good. Then they'll move this along. I'll get it to the front of the court. Make sure you have your current work schedules available, the child's schedule, and you have the right to argue about what's going on with CPS, Mr. Lofton and Miss Watson. You have the right to have them contact the worker as well to tell them about cooperation and what's going on with the child. That way everybody's up front because I'm not exactly sure what's going on. I just know that there's some indication by the motion that CPS is involved. But I will get this to the front of the court. That order will go out Monday. The fees are waived, so they'll be contacting you in the next 2 to 3 weeks. Make sure you have your current pay stubs available, as well as, like I said, your schedule and the child's schedule, so they can make a recommendation if you guys cannot come to an agreement. All right?
All right.
Take care to both of you. Have a good day. Stay safe. And yes, in Grand Rapids, I actually do get bananas every couple of years.
Tiny, tiny bananas.
They're 5 to 6 inches long, and they taste great because they ripen on the vine.
Nice.
So it's actually pretty cool. Bananas. I also get the distinction of having the only office in the courthouse that is actually bananas. But
do you have fruit flies though? We have fruit flies.
We did for the first year, but they've stunted in growth, and I think I need to replant them. But my comment used to be when I was in the office 5 days a week because I talked to myself. There was a lot of hot air and humidity, so the bananas grew very, very well. In any event, so with that note, because we deal with such awful things here, I try to keep it at a lighter note. But let's get into this. So we're here in the matter of Welch versus Mall, case number. I believe that this is your motion, Mr. Welch, correct?
It is not motion. No, I believe it's our motion.
Okay, because I've got a plaintiff's response to defendant's motion, and okay, yeah, because I've got the response. So that was by you, Ms. Welch?
Yes.
Okay, thank you for doing that.
Yeah.
Sorry, it looked like it was written by an attorney. That's why I was like, I got confused. I thought this was actually your writing, Miss Quist, so this is your motion, so please
Thank
proceed
you.
on it.
Thank you. We have a couple of agreements, I believe. We agree to no alcohol during parenting time. We agree to no motorcycle. Are you in trouble?
No, I'm.
Okay. We agree to.
I just realized I had the
You were
wrong file in
unplugged.
front of me. Also, on top of it.
We agree to no motorcycle rides. And I think we all agree that it's in the minor child's best interest to have a strong relationship with both parents, as the statute mandates, MCL 722.27A. I do believe that it's in Violet's best interest to have a strong relationship with both parents. No matter how we got here, this is where we are.
Right.
I did receive the response, and I just have a counter with some tweaks to it, because I'm trying to reach a resolution here.
Right.
I look for things that will make everybody unhappy, as I always say.
Well, pursuant to the statute, if the parties can agree on something, the court must enter it. So I do have a backup plan because case law indicates we have to review it if parenting time has been limited or constrained. In the past, the court must review it every few months to a year without a change of circumstance until we find out if it's still appropriate to constrain it or if it's appropriate to let the constraints go. So that's my backup. But if the parties, I'll let you and Ms. Welch talk about this and we'll see how it goes. All right.
Okay. I was going to say, and that's kind of built into status conferences. Phase 1 would be the first 3 visits at Cascade Park or the library or JT's Pizza. I'm very familiar with Cascade, for 2 hours. This is phase 1. Grandma may be present. Plaintiff may be present. The second 3 visits, grandma would supervise, no plaintiff. Mr. Mall would use the backtrack breathalyzer at the beginning of each visit. I think that's fair. You can get them on Amazon for $60. The second 3 visits would be 4 hours each. I think Violet should be in counseling with Lynn Jackson or Mary Lear. With Violet and Mr. Mull, I think it's important that they rebuild their relationship and that a therapist monitor that and make sure that it goes smoothly.
And that would be at his cost because this is
absolutely 100%. That would be phase 1. Phase 2, alternating weekends, Saturday 10 a.m. to 6 p.m., Sunday 10 a.m. to 6 p.m. Grandma would supervise. The backtrack utilized at the beginning of parenting time and at 4 p.m. to make sure that sobriety is maintained during the visit. I think it's up to a therapist to make a decision regarding the introduction of Mr. Mull's fiance and children. I think that should be her decision as to when it's appropriate. I believe that monthly status conferences with referee Kmetz is appropriate. I think phase 2 should last for 6 weeks. Phase 3 would be alternating weekends, Friday to Sunday, unless contraindicated.
Well, why don't we do the first 2 phases because we'll meet before phase 3 would come into play,
That's
right?
absolutely fine.
It would be. I would meet you in about 8 weeks to let the first. But Miss Welch, is that okay with you?
Well, this is the first time I'm hearing of these alternate.
Well, you offered a 1 through 6 phase thing as well. So I think what she was doing was just altering what you had requested.
Right. I did receive that.
Yeah. And I agree with the counselor. I agree with the 2 agreements of the parties. There needs to be the sobriety and there needs to be the breathalyzer. But Ms. Welch, I know you just heard it, but what are your thoughts?
My thoughts are, since it's been such a long period of time since the defendant has been he's really never been a consistent presence in my daughter's life.
Right.
Since 2022, he has missed 336 visits.
Well, and that's the problem. That's why we start this very, very slowly.
Yes.
Normally I do not start it unless but you seem to be agreeable that one of the family members would be an okay supervisor, Ms. Welch?
No.
Okay. Because normally, Ms. Quist, I do start it with professional supervision. And Mr.
I'm fine with that also.
Yeah, Mr. Mall, the reason that I do that is because then I have a professional who can see the interactions. And 80% of the time, the interactions are appropriate. Now I've got somebody who actually knows what they're doing, Ms. Welch, to say, hey, yeah, the kid gets along with him very well. She looks forward to seeing him. She's not scared. So that's why I would want a professional, is because then I have a third party on here that has no vested interest in the case.
Yep. Okay.
And if those are going well, then we start to control how to increase that.
Mhm.
Okay. And that would also mean, Mr. Mall, no offense, but until we get everything set in with your relationship with your child, then we'll start bringing in the rest of your family, because the child also needs to know her half siblings or other
Right.
step
agree.
siblings. I mean, it's just that we
Mhm.
got to do this without, luckily she's very young. Doing this with 12 and 14-year-olds is not as easy as doing this with children of this age. They're a little bit more willing to accept things. So what I would order at this point is I would order what has been by agreement. I would order the counseling to begin. If there's an agreeable counselor, Ms. Welsh, that's fine. But either one of the two that Ms. Quist has suggested the court has used prior. So either one would be appropriate. But again, that would be at Mr. Mall's.
I'll see which one's available. You know how
Right.
that
Yeah.
goes.
Now I can take her recommendation as to when, but I can't give her the authority to order that the other party be. So
I understand.
the court cannot abdicate its authority on what parenting time is. The court can give instructions and say, I will take into account if the counselor says the kid's ready, everybody's ready, we'll do this. Because, family's more than just a mom and dad. Family's also grandparents, aunts, uncles, and I don't know if you're remarried, Miss Welsh, or not, but they're, extended family and other parties. So it happens. So, but I would order those two things, and we'll see each other in about 8 weeks. We'll send out a notice for a settlement conference where we can informally figure out what to do. And I will reserve the ability to send this to the front of the court if necessary.
I have a question.
Sure.
Outside, is the counseling between Violet and Mr. Mole?
That's the child. Yes.
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 And is there any parenting time outside of counseling?
I'm ordering supervised at the Y.
Okay, that's my question. Is there a
But I would
frequency-
want at least one meeting with the counselor prior to the supervision starting, because I don't want her thrown in. Miss Welsh, does your child know the father?
Actually, I don't know how much of a coincidence it was, but we ran into him on the 27th, and she was very uncomfortable in the situation.
Which is why I want the counselor involved before we start the supervised parenting time.
Okay.
So the counselor will generally meet with you, Mr. Malt, and the counselor will meet with the child, and the counselor will meet with both of you in a controlled environment. And then supervision can start.
Okay, so at least one visit, Mr. Mole. I just want to make sure I have this correct. Violet, and then starting with both, and then starting at the Y.
Correct. And I'll get you the order for the Y when it's appropriate. So I'll get the order for the
there
Y.
a
I'll get you the order for the
frequency?
Y on Monday, but it won't start until appropriate
I agree.
after the counselors. All right.
Is there a frequency for visits at the Y? I just want to make sure
The Y generally controls that with the parties.
Okay.
Miss Welsh, you'll need to be talked to the Y too, because obviously we don't know your schedule, and Mr. Mall, you'll need to contact them. And once it's appropriate to start those visits, they'll start arranging those visits, and we're going to meet soon enough to figure out how they need to continue or when they get expanded.
Okay.
I have
That'd
a
be
question.
fantastic.
Sure.
Is it possible that I attend with my daughter on the first?
That would be up to the counselor.
Okay.
So because the counselor should be informed of all of you, and it probably would be appropriate that you be there.
Right.
So,
She might be comfortable.
but it may or may not be appropriate for you to be in the counseling room.
Mhm.
So, but again, I don't mess with professionals who are doing their jobs. And we have some very good ones out there who know how to do this better than we do. And they're experienced in doing this. So I would trust their judgment on who should be there and how long and when.
Okay.
Mr. Mall, you had another question?
Basically, that just summed it up.
Okay. Yeah, because what the whole thing here is trying to make the child comfortable with you, Mr. Mall, and then make sure the child is comfortable with you. Once the child is comfortable and we can see through professional observation that everything is going well, we start increasing this, and eventually you get normalized parenting time. That's the goal of the law. That's what the law says we have to do. If, however, something happens, it gets curtailed and gets cut off again or suspended or back to professional supervision. I've had some of these bounce around a lot, but the majority of them, I will say, slowly over time, everything, especially with children this age, everything gets normalized within about a year and a half. Okay. It takes sometimes about a year. All right. So I can't undo what you guys have been doing since 2020.
Right. It's
All righty.
forward, and that is in the past.
Yep. Well, it's in the past, but it has an effect of the present. But
I get it.
what we're going to try and do is negate that and get this moving on so that it normalizes. Okay.
Okay.
You are both the parents of this child. I can't terminate that. This is not a neglect case. All righty. Take care, and we'll do everything that's in the best interest of the child. And that includes the presumption that parenting time is in the best interest of a child, as long as it can be done safely. Have a good morning. I'll see you in about 8 weeks.
Thank
Thank
you.
you.
You too.
Thanks,
Take
Reverend
care.
Kmetz.
All right. Next. Take care, everybody.
Disconnect.
Enjoy the weather this weekend.
You
Nice
too.
to meet
Thank
you, ma'am. Nice to meet you, ma'am. Sorry I had to put you on the sidelines.
No, you're fine. Thank you.
All right. Take care, everybody. Nobody puts
Okay.
baby in a corner. Never mind. Ability. Next.
I do.
Next, we can do sannyasi.
All right. We are here on a motion by the plaintiff, the defendant counter plaintiff to enter a default judgment of divorce in this matter. I will note that this matter has been sent to the front of the court two times, and both cases were both recommendations were dismissed because of lack of cooperation. This matter was filed in court on September 13th, 2023 by Mr. Sannyasi. Mr. Sannyasi then did not appear for several hearings and several incidents that were necessary for the court to make decisions. Because of the lack of cooperation of the plaintiff, the defendant was allowed to file a counterclaim for divorce. Defendant was subsequently defaulted due to lack of cooperation and not showing two scheduled court appearances. At this time, it is the request of the defendant counter plaintiff to enter a default judgment against the plaintiff counter defendant. If that's not confusing enough for the interpreter. The court will proceed in this matter and swear both parties in to take the necessary testimony. Ambika Basnat, please raise your right hand.
Ambika Basnatji, तपाईको दाहिने हात उठाउनुहोस्.
Do you swear or affirm? Ma'am, raise your right hand, please.
तपाईको दाहिने हात उठाउनुहोस्, अम्बिकाजी.
The other right.
दाहिने.
All right. Do you swear or affirm to tell the truth? Please keep it raised, ma'am.
उठाइराख्नुहोस्, तपाईले कसम खानुपर्छ, उठाइराख्नुहोस् हात.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in giving testimony?
Yes.
You may put down your hand, sir.
राख्नुहोस्.
Ms. Besnet, you've received the complaint of divorce filed by Mr. Sannyasi on September 23rd of 2023.
Yes, I had received.
And you reviewed it, and all the allegations in that complaint were true and accurate at that time?
No, they were not true.
What was untrue about them?
Oh, I see. The things that were in there, written in there, were all true and they were correct. They were about divorce and child custody, things like that. They were correct.
Yes, because you filed a counter complaint that says about the same stuff. On or about October 13th, 2023, correct?
Yes, that is right.
And before filing your counter complaint, you were a resident of Kent County in the state of Michigan for at least 6 months?
Yes.
And you were married to Tika by a person authorized to perform marriages?
Yes.
Oh, yeah, I found it. Right.
And there's been a breakdown of that marital relationship to the extent the objects of matrimony are broken and irreconcilable?
Yes.
And you have presented to this court a judgment of divorce that you believe to be a fair and equitable division of your marital assets, debts, and all issues of your marriage?
त्यो त सही हो कि तर एउटा कुरा चाहिँ मलाई के घर बेचेको थियो यसको पैसा आएको छैन हैन त्यो पैसा मैले त्यहाँ उले नि पेश गरेको थियो मैले नि गरेको थिए घरको पैसा चाहिँ मैले पाएको छैन
That is correct, Your Honor. One thing is, I have not received the proceeds from the sale of the house, my portion of the proceeds.
And that is taken care of in this judgment to get you your portion of the proceeds?
गरेको छ तर मैले पाएको छैन
It is mentioned there, but I have not received it.
It hasn't become a court order yet.
किनभने अदालतले त्यो तपाईले पाउनुपर्छ भनेर आदेश दिइहालेको छैन अहिले.
हजुर
Okay.
And you believe this judgment is in the best interest of your children?
हजुर हजुर
Yes, yes.
And you are not currently pregnant?
छैन
No.
Okay. Mr. Sannyasi, you heard that testimony?
मैले सुने. I heard it.
Is it true and accurate?
उहाँले जे जति कुरा भन्नुभयो त्यो सही सत्य छ.
त्यो गलत छ किनभने पहिले हामीले कुनै पनि सम्पत्तिहरू बाँडफाँड गरेको छैन हैन त्यो घरको पैसा
That is false. And particularly, she mentioned about the division of the property. It was fair and equitable, but that has not been done, and it is not true.
It's not been done because you have disobeyed this court's order and you did not turn over the proceeds to be placed into a protected account. The show cause hearing to hold you in contempt was adjourned. And until you showed up to this hearing, which I was doubtful you would, you have not been cooperative with any of the hearings of this court. While the contempt charge is not before this court at this moment, the contempt charge is very obvious.
Okay.
You were to turn over those proceeds and you never did. After review of this court file and the previous orders of this court and your lack of cooperation, I have no choice but to say that this judgment is fair and equitable and does take care of the issues between the parties.
र यी सबै कुरालाई हेर्दाखेरि चाहिँ जुन जजमेन्ट हामीले दियौं जुन अदालतले दियो आदेश त्यो फेयर छ र त्यो तपाईहरुको हितमै छ जुन अवस्थामा अगाडि बढेको थियो त्यसको आधारमा भन्ने हुन्छ.
So I'm recommending the entry of this order. There is a 21-day appeal period on this.
त्यसले गर्दाखेरि जुन अदालतले आदेश दियो त्यो सही भनेर राख्नुभयो अहिलेको लागि चित्त बुझेन भने 21 दिन भित्रमा तपाई अपिल अर्को अदालतमा पुनरावेदन गर्न सक्नुहुन्छ अरे.
And that will be the ruling of the court unless there are any questions from Mr. Cox.
त्यो भएर पनि हो
एकछिन रोक्नु